Well, we have breaking news in Luigi Mangione's state criminal prosecution. It appears that the judge in the Manhattan state case against Luigi has dismissed the top count of murder in the first degree. And you know I'm here to talk about it. And you also know I'm here to say, I told you so, because I've been right about this and pretty much everything else on this case this entire time, despite what some haters might like to say because they don't like hearing the truth. In order to proceed with a felony case against anybody, a grand jury has to indict the person on each and every one of the charges that the DA wants to pursue. So it's unlike a misdemeanor prosecution, because with misdemeanor cases, I guess, the thought is we're not as concerned about people being prosecuted for misdemeanors because the worst thing that could happen to you if you're convicted of a misdemeanor is 1 year in jail. Now, I know how ridiculous that sounds because a year in jail is quite scary, but in practice, when you're charged with a misdemeanor, typically those cases don't end up with jail time. And so if you had to indict every single misdemeanor case that was brought, the criminal justice system would grind to a halt. But with felony charges, because the potential result or the potential punishment on a felony could be so severe, there is this idea of like a check and balance type of thing where you can't just be arrested by the police and prosecuted by the DA for a felony without, I guess, the community say so. And that's what a grand jury is. It's only grand because of the amount of people on it, 23 versus 12, which is a trial jury, also known as a petit jury or petite jury. Anyway, before you can proceed on felony charges, you have to present a certain amount of evidence to a grand jury, and that grand jury has to indict. A grand jury does not have to be unanimous to indict. It just has to be the majority. That's another difference between a grand jury and a trial jury. But the burden of proof in a grand jury is super low. That's why they always say you can indict a ham sandwich, because proof at the trial level for a conviction requires proof beyond a reasonable doubt. But in a grand jury, you only have to have reasonable cause to believe that the crime was committed by the person the DA is claiming committed the crime. It's basically the same level as probable cause, which is what the police need to make an arrest. And so if a jury votes, a jury has to vote on each and every one of the counts, a grand jury, in order for the DA to prosecute you on those counts. Now, very rarely, a prosecution will go into the grand jury, present the evidence, and a grand jury will, what we call, blow out the case. They will dismiss the case or come back with a no true bill. In that situation, it's over. A DA can't go back and try it again for the same exact charge. It's dismissed, and they can't pursue a case with those counts. They can only pursue the case on the counts that a grand jury indicts on or comes back with a true bill. Now, in Luigi's case, the grand jury did come back with the indictment on these counts, including the murder in the first degree count, which, as we've discussed, this is not the federal case that we're talking about right now. This is the state case. We're not talking about stalking. We're talking about terrorism. And that the bump up from a murder 2, which in New York just is what you typically think of as premeditated murder, to murder 1, which is the highest level of murder, you have to have some sort of aggravating factor. It can't just be premeditated murder. It has to be premeditated murder plus. So the plus in this case was that it was terroristic in nature. And so they presented whatever evidence that they seemed to have, or a lower level of evidence, to a grand jury, and they indicted Luigi on it. However, at a certain point in time in the case, towards the beginning, I know it doesn't feel like the beginning, but we're still relatively early in this case, the defense attorney can say, and we typically do, that they want the judge to inspect the grand jury minutes. What does that mean? It means that it's another form of checks and balances. In a grand jury, there's no judge. The defense attorney could be there if the defendant testifies, but otherwise the defense attorney is not there. So that's another reason it's so easy to indict, because it's all one-sided. Basically, it's all prosecution witnesses, and it's very limited and targeted testimony that's being presented, basically the jury doesn't get to hear the other side of things. They don't hear, the witness is not cross-examined, they don't hear another side of the story, nothing. And so it's important for a judge to look at that secret proceeding and make a decision on whether the prosecution, did present enough evidence for a grand jury to indict, or whether they did, things that they weren't supposed to do in that grand jury. Now, those grand jury minutes are inspected in camera. That means in private by the judge before those minutes get turned over to the other side. And so as a defense attorney, you ask for the judge to review those minutes for the sufficiency of the minutes and the sufficiency of the charges. So I've been dealing with clients this morning, but I haven't seen the proceedings, or I haven't heard anything except that I saw people tweeting out that the top count, the murder one, was dismissed. So this is all, I don't want to say speculation, because it's not total speculation. I have a lot of experience, 20 years of experience here, even though I had like some insane Twitter troll tell me that I don't know what I'm talking about, and that I've been wrong about everything in this case, even though I've been right. But it's kind of speculation though, because I haven't seen every single thing that has happened. So I'm sure people in my comments will advise and correct and add information as it comes through. I'm going to be in court later today, so I may be delayed in my responses to those comments, but please do leave comments for me and for all of the viewers here so that we can have a nice discussion in the comment section. But basically, after seeing that the count was dismissed after a review of the grand jury minutes, or that the judge decided that there wasn't enough evidence in the grand jury to sustain that count, this is what I surmise has happened, what I've just told you. So what this means is that count is dismissed and it's over. So the top count now is murder in the second degree, premeditated murder. It does still carry a hefty sentence, 25 to life. So it's not like Luigi's in the clear, but it is a huge, huge win. Real quick, also added like inside baseball type of vibes here. I just want you to keep something else in mind. I want to say that there's one small detriment to this happening, very small, but significant enough that I think it's important to mention. Keep in mind that if this case does go to trial now, there will be no discussion on the murder one count. And so sometimes a defense team strategy is to tell a jury, like, look at all these overcharged counts. Obviously, the DA either doesn't know what they're doing or is trying to crucify this person, and they don't have proof beyond a reasonable doubt. And so how can you trust anything that they're telling you? How can you trust them? Therefore, you can't trust any of the evidence, and you should acquit. And that works a lot, by the way, in cases that are overcharged. And there's a ton of overcharged cases in our system. Here, now that the count was dismissed, there's going to be no evidence of murder one, or talk of murder one, or charges of murder one at trial. So the defense actually loses a little bit of their edge with respect to that strategic argument. They're not going to be able to tell the jury, like, hey, this guy was overcharged. And in case you're wondering, no, they can't sum up, for example, on anything that's not in evidence at the actual trial. So they can't tell the jury, like, hey, by the way, before you guys got here, this case was a murder one case. They can't do that. So they do lose that. Obviously, the better result is that this charge is dismissed. So I'd rather this happen. But it's just an interesting thing to keep in mind, that they could have used that as a strategy at trial if this goes to trial. And now they kind of lost that ability. Any questions or comments? Like, share, all that good stuff. And we'll probably have more videos on this later.